And Mr. Halasz, you have the opportunity now to speak. You have the opportunity now to speak. What would you like me to know?
Your Honor, I just want to say I'm sorry for what I did.
Okay.
That's it, Judge. We would thank the court.
All right. You know, I have two requests here. I have one for community control and one for the max. And I can tell you that this case is very troubling to me. And when I saw the video, it was, even though I wasn't there, even though, you know, this is, what, 8 months later or 7 months later, I can tell you that I felt the fear of him going through the halls, stalking his victim. After consideration of the record, the oral statements made today, looking at the pre-sentence investigation report, looking at the purposes and principles of sentencing under Ohio Revised Code, Section 2929.11, the seriousness and recidivism factors relevant to the offense and offender pursuant to Revised Code, Section 2929.12, and the need for deterrence, incapacitation, rehabilitation, and restitution, the court does find that a prison term is consistent with the purposes and principles of sentencing set forth in Section 2929.11 of the Revised Code, and finds that the offender is not amenable to an available community control sanction. Furthermore, this court has considered the factors set forth in 2929.12 and finds that a prison term is commensurate with the seriousness of the defendant's conduct, his impact on the victims, and is reasonably necessary to deter the offender in order to protect the public from future crimes, and would not place a necessary burden on government resources. This crime was, in my opinion, so horrible that even I know all of the staff has to also have PTSD from this, because of the way it occurred, and the stalking, and sort of and the seriousness of the injuries. These injuries are extremely serious. I do not think, and as you can tell, I don't believe that community control is appropriate in this case. And I am mindful of his mental condition, that he has a schizo affect. Let me just make sure I'm saying it correctly here. I am mindful of his condition, and I have the reintegration plan that was prepared on behalf of by the mental health jail liaison specialist, Lottie Gray, and I have reviewed this. But even with all of this, I believe that this is a serious crime, and I believe that the treatment that he needs, that he should be able to get, if it's not the best, I get it. I mean, it's in prison, but I believe that that's where he needs to be at this time. With that being said, it's not often that I say what I'm going to say, but I do believe in this case, as to the count 1 attempted murder, I believe that the 11 years is what he should be sentenced to. And I don't say that often to give the max, but I think this is an instance where the max is not only justified, but I think necessary to help deal with the pain and the trauma that these victims, and it wasn't just the one victim. I mean, you have victims all of the employees who were there that day, they're all victims here. I feel like a victim just by seeing the video. I mean, that's how it has affected me. Pursuant to Reagan Totes, Mr. Halasz, based upon your conduct in the prison, if your conduct is against what the rules and regulations are, they can keep you up to an additional 5.5 years, so up to 16.5 years. If your conduct remains in line with the policies and laws of the prison, then you would be out at 11 years. Do you understand that?
Yes, Your Honor.
Okay. Upon your release from prison, the State of Ohio Adult Parole Authority, and not this court, would have a mandatory minimum of 2 years up to a maximum of 5 years of what is called post-release control. If you fail to meet the terms and conditions of any post-release control supervision imposed upon you, then the Adult Parole Authority can modify and/or extend your supervision and make it more restrictive. They can incarcerate you for up to half of the original sentence imposed by this court. They can charge you with a new offense called escape, another felony where you could face additional prison time. And if you commit a new crime while on post-release control, you can face the maximum penalty under the law for the new crime committed. Unless the defendant is serving a prison term that cannot be reduced under the law, defendant may be eligible to earn 1 or 5 days credit towards his sentence for each completed month during which the defendant participates in educational or other programs. In addition, the defendant may earn up to 5 days credit towards his sentence for successful completion of a second such program. This earned credit is not automatic but must be earned by the defendant. The defendant is assessed court costs in this case. However, those court costs can be paid through court community work service within the confines of the prison with the warden's approval in lieu of any cash payments. Mr. Halasz, you have the right to appeal this sentence within 30 days of the entry of the court's sentencing decision, and you have the right to have a notice of appeal timely filed on your behalf. If you're unable to pay the costs of an appeal, you have the right to an appeal without payment. If you're unable to afford counsel for an appeal, counsel will be appointed for you. If you're unable to pay the cost of documents necessary to effect that appeal, those documents will be provided to you without cost. Do you understand everything that I've said?
Yes, Your Honor, I understand.
Do you have any questions you need to ask me at this time?
No, Your Honor.
All right. Defendant is ordered to the custody of the sheriff for transfer to the appropriate correctional facility. Credit will be given for all time served in case number 691650.